Picture this. It's a crisp autumn morning in 1386, and the entire population of Falaise, France, has gathered in the town square to witness an execution. The condemned prisoner stands before the scaffold, dressed in human clothing, a white shirt, brown jacket, and even white gloves on her hands. The crowd murmurs as the executioner raises his axe. But this is no ordinary criminal about to meet her fate. The prisoner being executed for murder is a pig. Her crime? Killing and partially eating an infant in her pen. Her trial? A full legal proceeding complete with lawyers, witnesses, and a formal verdict of guilty. Her execution? Carried out with all the pomp and ceremony reserved for human criminals because in medieval Europe, animals were considered fully responsible moral agents capable of sin, crime, and punishment. Welcome to Professor Archive, where we uncover the strangest truths hidden in history's shadows. I'm your host, and I'm about to take you on a journey through the most bizarre, bewildering, and downright unbelievable laws that governed medieval European life. These aren't just quirky historical footnotes. They're windows into a world where logic operated by completely different rules, where the line between the sacred and the absurd was razor thin, and where survival often depended on navigating legal systems so strange they make modern bureaucracy look like a masterpiece of clarity. Prepare yourself for laws that mandated trial by combat between a man and a woman, regulations that made it illegal to die in certain places, and statutes that could sentence you to death for wearing the wrong color. Because medieval Europe wasn't just a different time, it was a different universe of human thinking. The pig trial I just described wasn't an isolated incident of medieval madness. It was part of a systematic legal framework that treated animals as moral agents subject to the same laws as humans. Between the 13th and 18th centuries, European courts tried hundreds of animals for crimes ranging from theft to murder to witchcraft. In 1474, a rooster in Basel, Switzerland, was tried and executed for the unnatural crime of laying an egg. The prosecution argued that roosters laying eggs was a sign of demonic possession and could summon Satan himself. The defense attorney, yes, the rooster had legal representation, argued that the bird couldn't help its biological functions, and that laying an egg was not a matter of criminal intent. The court ruled that intent was irrelevant when dealing with supernatural crimes and sentenced the rooster to be burned at the stake. But perhaps the most elaborate animal trial in medieval history took place in 1519 in Stelvio, Italy, where an entire colony of field mice was charged with damaging crops. The case dragged on for months because the mice failed to appear in court despite being served with legal summons. Their court-appointed lawyer argued that his clients were too young to understand the charges, that the journey to court was too dangerous due to cats along the route, and that many of the defendants were pregnant and couldn't travel. The judge, taking these arguments seriously, postponed the trial multiple times and eventually issued a judgment in absentia, banishing the mice from the territory. These animal trials reveal something profound about medieval legal thinking: the belief that all of creation existed within a single moral and legal framework ordained by God. If humans could sin and be punished, then animals, as God's creatures, could too. This wasn't primitive thinking, it was the logical extension of a comprehensive worldview that saw divine justice as universal and absolute. But animals weren't the only surprising defendants in medieval courts. Inanimate objects could also be tried and convicted. In 1499, a German town put a brewing vat on trial for producing bad beer that made people sick. The vat was found guilty and sentenced to be destroyed. Church bells that cracked during important ceremonies were sometimes excommunicated and removed from service. Even dice could be banned from towns if they were suspected of being cursed or encouraging gambling. The logic behind these trials reflected the medieval understanding of causation, which was far more complex than our modern scientific worldview. Medieval people lived in a universe where objects could be possessed by demons, where the natural world was constantly influenced by supernatural forces, and where justice required addressing not just human actions but the cosmic order itself. This brings us to one of the most bizarre categories of medieval law: regulations governing the afterlife and death itself. In medieval Seville, it was illegal to die without a will, and the bodies of people who died intestate could be refused burial in consecrated ground. But even stranger was the law in medieval London that made it illegal to die in the Houses of Parliament. This wasn't just a symbolic rule. Violators could technically be charged with a felony, though obviously they were in no condition to stand trial. The reasoning behind these death laws reveals the medieval obsession with proper legal and spiritual procedures. Dying without a will was seen as a failure of Christian duty because it left family members without clear guidance and could lead to disputes that disrupted social order. Dying in Parliament was problematic because Parliament was technically a royal palace, and dying in the presence of the monarch without permission was considered a form of treason. But perhaps the most macabre death law came from medieval France, where corpses could be tried and convicted of crimes committed while alive. The most famous case involved Pope Formosus, whose body was exhumed and put on trial in 897 CE. The corpse was dressed in papal vestments, seated on a throne, and formally charged with perjury and violating canon law. When found guilty, the body was stripped of its vestments, 3 fingers were cut off, and the remains were thrown into the Tiber River. These posthumous trials weren't just expressions of political revenge. They reflected the medieval belief that death didn't end legal responsibility. If someone died while under investigation or after committing a crime, their eternal soul could still be held accountable, and earthly justice had to be completed for cosmic order to be restored. The medieval obsession with cosmic order also produced some of the most elaborate sumptuary laws in human history. Regulations that controlled who could wear what based on their social status. In 14th century England, it was illegal for anyone below the rank of knight to wear clothing that cost more than 2 marks per yard. Peasants were forbidden from wearing any fabric other than russet or brown wool, while merchants were prohibited from wearing silk or silver decorations. But these weren't just about maintaining social hierarchies. They were about preventing moral and cosmic catastrophe. Medieval theologians argued that wearing clothing above your station was a form of pride, one of the 7 deadly sins, and could bring divine punishment, not just on individuals but on entire communities. When the Black Death swept through Europe, many blamed it on the widespread violation of sumptuary laws, arguing that God was punishing humanity for its vanity and social disorder. The enforcement of these laws could be bizarre and brutal. In medieval Florence, special officials called sumptuary police would patrol the streets looking for violations. Women caught wearing silk when they weren't entitled to it could be fined enormous sums, publicly humiliated, or even exiled. The laws were so complex that some towns published detailed guides explaining exactly what each social class was allowed to wear, down to the number of buttons permitted on a coat. But the most absurd sumptuary law may have been the regulation in medieval Nuremberg that required prostitutes to wear yellow cloaks with blue trim, so they could be easily identified. The law was so specific that it even regulated the exact shade of yellow and the width of the blue trim. Violation of this dress code was punished more severely than many forms of theft. Food laws in medieval Europe were equally bizarre and often deadly serious. In medieval London, it was illegal to eat meat on more than 2 days per week during certain seasons, and violators could be excommunicated or fined. But enforcement was inconsistent and often corrupt. Wealthy people could usually buy exemptions, while poor people faced severe punishment for the same violations. The most dangerous food law involved the regulation of bread, which was considered so essential to social order that its production was hedged with elaborate legal requirements. The Assize of Bread, established in England in 1266, set precise standards for the weight, price, and quality of bread. Bakers who violated these standards faced a punishment called the pillory, where they were locked in wooden stocks in the town square with the offending loaf tied around their necks. But bread laws could be even more severe. In medieval Paris, bakers who sold underweight bread could be dragged through the streets on a wooden sledge, and repeat offenders could be banished from the city forever. The reasoning was that bread was literally the staff of life, and cheating customers on bread was tantamount to attempted murder. The most elaborate food regulations involved feast days and fasting periods, which could change from week to week based on complex religious calendars. Medieval people had to navigate rules that made certain foods illegal on certain days, with violations punishable by excommunication, fines, or physical punishment. Fish was generally permitted on fast days, but the definition of fish was surprisingly complex. Beaver was considered fish because it lived in water, but barnacle geese were considered fish because medieval people believed they grew from barnacles attached to ships. Marriage laws in medieval Europe were so complex and contradictory that most people probably violated them regularly without knowing it. The Catholic Church prohibited marriage between relatives up to the 7th degree of kinship, which meant you couldn't marry anyone more closely related than a 6th cousin. In small medieval communities, this made legal marriage almost impossible since everyone was related within the prohibited degrees. But the church also prohibited marriage during certain seasons. No weddings were allowed during Advent, Lent, or the week surrounding major religious holidays. This meant that there were only about 4 months per year when marriage was legal, creating a bizarre situation where most of the population was either unmarried or living in technically illegal relationships. The penalties for violating marriage laws could be severe and often targeted women disproportionately. A woman who married within the prohibited degrees of kinship could be forced to do public penance, walking barefoot through town wearing only a white sheet. Repeat offenders could be imprisoned or exiled. Men faced similar penalties, but enforcement was often less strict. Perhaps the strangest marriage law was the requirement in some medieval towns that couples prove their fertility before being allowed to marry. In parts of medieval Germany, engaged couples were required to spend a night together under supervision to demonstrate that they were capable of producing children. If no pregnancy resulted within a reasonable time, the engagement could be annulled. Professional regulations in medieval Europe created some of the most absurd legal situations in history. Guild laws were so restrictive that they often prevented people from doing basic tasks necessary for survival. In medieval London, it was illegal for anyone except licensed professionals to repair their own shoes, cut their own hair, or even bake their own bread for personal consumption. The most ridiculous professional law may have been the regulation in medieval Paris that prohibited barbers from performing surgery on days when they had cut hair. Since barbers were also surgeons in medieval times, this created a system where you had to choose between getting a haircut and potentially needing medical treatment on the same day. The law existed because authorities believed that haircutting made barbers' hands unsteady for the precise work of surgery. Guild laws also created bizarre conflicts between professions. In medieval London, a legal dispute arose between the company of barbers and the company of surgeons over who had the right to perform tooth extractions. The case went on for years and involved detailed arguments about whether tooth extraction was primarily a haircutting activity or a surgical procedure. The final ruling established that barbers could extract teeth on Mondays, Wednesdays, and Fridays, while surgeons could do so on Tuesdays, Thursdays, and Saturdays. Sundays were reserved for emergency extractions by either profession. The regulation of ale brewing created particularly complex legal situations because brewing was primarily a women's occupation in medieval times. Alewives, as they were called, had to navigate laws that regulated not just the quality and price of their product, but also their personal behavior. In many towns, alewives were required to wear distinctive clothing so customers could identify them. And they were prohibited from selling ale while pregnant because authorities believed pregnancy affected the quality of the beer. But the most absurd brewing law was the requirement in some medieval English towns that alewives taste their own product in front of customers to prove it wasn't poisoned or spoiled. This led to the bizarre situation where women were legally required to become drunk in the course of their daily work, which then made them vulnerable to other laws prohibiting public intoxication. Religious laws in medieval Europe created some of the most elaborate and contradictory legal frameworks in human history. The prohibition against working on Sundays was so strict that it was illegal to light fires, prepare food, or even save drowning people unless you could prove it was a life or death emergency. But the definition of work was subject to constant legal interpretation, leading to situations where people could be prosecuted for activities we would consider basic self-care. In medieval England, it was illegal to bathe on Sundays because washing was considered work. This led to the peculiar situation where personal hygiene became a legal issue, with authorities having to determine whether washing your hands before eating constituted illegal labor or necessary preparation for a meal. The most complex religious laws involved the regulation of magic and superstition. The Catholic Church officially prohibited belief in magic while simultaneously promoting belief in miracles, creating a legal framework that was almost impossible to navigate consistently. Activities that might be considered miraculous when performed by a saint could be considered witchcraft when performed by a peasant. This led to the bizarre legal concept of white magic versus black magic, where the same spell or ritual could be legal or illegal depending on who performed it and what results it achieved. Healing herbs prescribed by a priest were considered divine medicine, while the same herbs prescribed by a village wise woman could be evidence of witchcraft. The witch trials that swept through Europe from the 15th through 17th centuries represent the logical extreme of medieval legal thinking. The Malleus Maleficarum, published in 1487, provided legal guidelines for identifying and prosecuting witches that were so broad that almost anyone could be convicted. The manual specified that refusing to confess under torture was evidence of supernatural assistance from the devil, while confessing under torture was evidence of guilt. But perhaps the most absurd aspect of witch trials was the use of swimming tests, where suspected witches were thrown into bodies of water. If they floated, it proved they were witches because the pure water rejected them. If they sank and drowned, it proved they were innocent. This created a legal system where being accused of witchcraft was essentially a death sentence regardless of the outcome of the trial. The legal treatment of Jews in medieval Europe reveals some of the most disturbing and bizarre laws in human history. Jews were required to wear distinctive clothing and badges to identify themselves, were prohibited from owning land or joining guilds, and were subject to special taxes and restrictions that changed frequently and arbitrarily. But the most absurd anti-Jewish law was the requirement in many medieval towns that Jews pay a special tax for the privilege of breathing Christian air. This breath tax was calculated based on the amount of time Jews spent in Christian territories and was sometimes collected daily. Jews who couldn't pay the tax could be expelled or imprisoned, creating a system where simply existing in certain places was a financial burden. Laws governing trial by ordeal represent perhaps the most alien aspect of medieval legal thinking to modern minds. The underlying assumption was that God would intervene in human affairs to ensure that justice was done. So physical tests could determine guilt or innocence through divine intervention. Trial by hot iron required the accused to carry a red-hot iron bar for a specified distance. If the burns healed cleanly within 3 days, the person was innocent. If they became infected, it proved guilt. Trial by hot water required plunging your hand into boiling water to retrieve a stone. Trial by cold water involved being tied up and thrown into a river. Sinking proved innocence because the pure water accepted you, while floating proved guilt because the water rejected you. These ordeals weren't just primitive superstition, they were formal legal procedures with elaborate rules and procedures. The church provided detailed instructions for conducting ordeals, including the prayers to be said, the procedures for blessing the water or heating the iron, and the criteria for interpreting the results. But perhaps the most bizarre ordeal was trial by combat, where legal disputes were settled through physical fighting. This wasn't limited to knights or warriors. Anyone could demand trial by combat, including women, elderly people, and those with disabilities. Special accommodations were made for unusual situations. When a woman challenged a man to combat, the man had to fight from inside a pit with one arm tied behind his back to equalize their physical differences. The most famous trial by combat in medieval history involved a woman named Marguerite de Carouge, who accused her husband's friend of rape. When her husband challenged the accused to combat in 1386, the stakes were enormous. If her husband lost, Marguerite would be burned alive for making false accusations. The combat lasted for hours before her husband finally killed his opponent, proving her innocence and saving her life. Legal procedures in medieval courts often resembled elaborate theatrical performances more than rational examinations of evidence. Witnesses were required to swear oaths on sacred relics, and the procedure for oath-taking was so complex that mistakes in the wording or gestures could invalidate testimony. In some courts, witnesses had to hold their right hand in the air while speaking and could be disqualified if they lowered it before finishing their testimony. The most absurd courtroom procedure was the requirement in some medieval jurisdictions that all participants remove their shoes before entering the court. This was based on the belief that shoes could contain charms or magical objects that might influence the outcome of trials. Court officers would search shoes for hidden objects, leading to lengthy delays as everyone's footwear was inspected. Medieval courts also employed a variety of bizarre methods for determining the truth of testimony. In some jurisdictions, witnesses were required to speak while holding a piece of bread and cheese in their mouths. If they could swallow the food easily, their testimony was considered truthful. If they choked or had difficulty swallowing, it was taken as evidence of lying. The legal status of children in medieval Europe created some particularly strange situations. Children under the age of 7 were considered incapable of sin and therefore immune from most legal punishment. But children as young as 8 could be tried and executed for serious crimes. This led to bizarre situations where siblings of different ages could receive vastly different treatment for the same offense. The most notorious case involved a 10-year-old boy in medieval England who was hanged for stealing bread. The court ruled that while his crime was relatively minor, his method of theft showed such sophistication that he must have been acting with adult-level criminal intent. The case established the legal principle that children could be judged as adults if their crimes demonstrated unusual cunning or premeditation. Medieval inheritance laws created some of the most complex and contradictory legal situations in history. In some regions, property could only be inherited by the oldest son, leading to bizarre situations where younger sons would challenge their brothers to single combat for the right to inherit. In other areas, property had to be divided equally among all children, leading to farms and businesses being subdivided into increasingly smaller and unworkable portions. The most absurd inheritance law was the requirement in some medieval jurisdictions that heirs prove their relationship to the deceased through trial by ordeal. Even when there was clear documentary evidence of family relationships, potential heirs could be required to undergo physical tests to prove God recognized their claims. Debt collection in medieval Europe involved some truly bizarre legal procedures. Creditors could legally seize a debtor's clothing, leaving them naked in the street, or could claim a debtor's shadow by standing between them and the sun. This symbolic seizure was considered legally binding and prevented the debtor from conducting business until the debt was repaid. The most elaborate debt collection procedure was distraint, where creditors could seize a debtor's property but were required to care for it until the debt was repaid. This led to situations where creditors became unwilling farmers, required by law to milk cows, feed chickens, and maintain farms they had seized as collateral. Medieval contract law recognized some truly strange forms of agreement. Contracts could be sealed with a handshake, a kiss, or by breaking a stick in half, with each party keeping one piece. The most binding contracts were those sealed with a religious oath, but this created problems when people made contradictory religious commitments. The church developed elaborate legal procedures for dealing with conflicting oaths, including the concept of mental reservation, where people could swear oaths while secretly intending different meanings. This led to increasingly complex legal language as authorities tried to prevent people from exploiting loopholes in oath-taking procedures. As we examine these bizarre medieval laws, it's important to remember that they weren't the products of primitive or irrational minds. They were logical responses to the challenges of maintaining social order in a world without modern institutions, scientific understanding, or communication technologies. Medieval legal systems had to address fundamental questions about justice, social order, and cosmic meaning without the tools we take for granted today. They couldn't rely on forensic science to determine guilt, so they used religious tests. They couldn't depend on police forces to maintain order, so they used elaborate social hierarchies and sumptuary laws. They couldn't separate religious and secular authority, so they created legal frameworks that addressed both earthly and spiritual concerns. Many of these laws seem absurd to us because we live in a world with different assumptions about causation, individual rights, and the role of government. But they made perfect sense within the medieval worldview, where divine justice was more important than human convenience, where social order was more valuable than individual freedom, and where spiritual concerns took precedence over material ones. The legacy of medieval law can still be seen in modern legal systems, though usually in more subtle forms. The presumption of innocence, the right to legal representation, and the requirement for evidence in criminal trials all have their roots in medieval innovations. Even some of the bizarre procedures we've discussed contributed to the development of more rational legal systems by demonstrating the problems with relying on supernatural intervention or arbitrary authority. But perhaps the most important lesson from medieval law is how deeply legal systems reflect the values and worldview of the societies that create them. Laws aren't just rules for governing behavior. They're expressions of what a society considers important, just and necessary for survival. Medieval Europeans lived in a world that was dangerous, unpredictable, and often beyond human control. Their laws reflected their need to find order in chaos, meaning in suffering, and justice in a universe that often seemed random and cruel. Whether they were trying animals for crimes, testing innocence through physical ordeals, or regulating clothing to maintain cosmic harmony, medieval people were attempting to create systems that would allow human societies to function in the face of enormous uncertainty. The bizarre nature of medieval laws shouldn't make us feel superior to our ancestors, but should remind us how much our own legal systems depend on assumptions and beliefs that future generations may find equally strange. Every legal system is a product of its time and place, reflecting the particular challenges and values of the society that creates it. The next time you encounter a law that seems arbitrary or outdated, remember the medieval pig trial in Falaise, the rooster executed for laying an egg, or the baker dragged through the streets with bread tied around his neck. Remember that every legal system is an attempt by humans to create order, justice, and meaning in a world that often resists all three. And perhaps most importantly, remember that the strangest laws often reveal the deepest truths about human nature. Medieval people, like us, were struggling to create societies that could balance individual freedom with collective security, divine justice with human mercy, and the need for order with the reality of change. Their solutions may seem bizarre to us, but they were sincere attempts to solve problems that every human society must face. In their strangeness, medieval laws offer us a mirror that reflects not just the peculiarities of the past, but the ongoing human struggle to create meaning and justice in an uncertain world. That concludes our journey through the most bizarre and bewildering laws of medieval Europe here at Professor Archive. From pig trials to posthumous prosecutions, from sumptuary police to swimming tests for witches, we've explored a legal landscape so strange it makes modern bureaucracy look like a model of clarity and rationality. If this deep dive into medieval legal madness has given you a new appreciation for both the complexity of the past and the assumptions underlying our own legal systems, make sure to subscribe and hit that notification bell. We've got many more explorations of history's strangest truths waiting for you. What medieval law surprised you the most? Share your thoughts in the comments below, and remember, the next time you think modern laws are confusing, at least you're not living in a world where your pig could be executed for murder or your rooster burned at the stake for laying an egg. Until next time, this is Professor Archive reminding you that the past is not just a foreign country. Sometimes it's an entirely different planet of human thinking.